From 1999 to 2001, 57 bills were made in the 11th Congress of the Philippines, turning 57 municipalities all across the country into cities. Of the 57, 24 were still municipalities by the 12th Congress. On September 24, 2001, Republic Act 9009 was signed, amending the Local Government Code of 1991, raising the average annual income requirement of a municipality to become a city from 20 million pesos to 100 million pesos. For most of Philippine history, there wasn't a sort of criterion or definition of what a city is. By the early 1990s, the Local Government Code was enacted, defining a city as an area with a population of 150,000 or possessing territory spanning 100 square kilometers. Cities such as Tagaytay and Vigan, despite not possessing both requirements, were declared as cities long before the established requirements. It's also another reason why cities would often encompass large sections of unused land. By the 13th Congress, 16 of the 24 municipalities filed bills for cityhood. They met the first requirement, but by that time, they had not reached the new income requirement. Considering these municipalities have filed bills before Republic Act 9009, their new bills instead included a provision exempting them from the new requirement. One by one, all 16 cities were established as cities by Congress. Cityhood wasn't just a label. Economic autonomy, authority to make amends on taxation, and a larger share of the national revenue. Not only does an area become more recognized, but it also means that economically, they have all the power and doesn't have to share with a province. Going back to the story, there was one person, or more so an organization, that did not like this. The League of Cities of the Philippines is an organization made up of all of the cities of the Philippines. Think of it as a group chat. Sure, you may have become a city, but being a part of the group chat makes you a real city. The League is kind of a help group for cities, helping each other through solving urban issues and aiding each other. And they were not big fans of this development. The League argued that allowing the 16 cities to be passed by Congress was a dangerous precedent, implying that Congress can make cities without meeting requirements, or maybe even others taking advantage of this situation. The share of national revenue would also decrease per city, as the inclusion of 16 new cities would decrease the average share. The League contested the cityhood of the 16 cities, suing the Commission on Elections, stopping the agency from conducting plebiscites for the 16 cities and establishing their citihoods. The League cited that the bills violated Section 10, Article X of the 1987 Constitution, as well as a violation of the Equal Protection Clause, or the fair treatment for cityhood based on the requirement, regardless of exemptions. The case went to the Supreme Court, where on November 8, 2008, by a vote of 6-5, the court regarded the exemptions of the average income requirement to be unconstitutional. As a result, the cityhood of the 16 cities were voided. They sent a motion for consideration in March and April of 2009, which were both denied. In December, the court voted 7-5, reversing its November 2008 decision and declared the exemption to be constitutional. The court ruled that the cityhood bills during the 11th Congress were made before Republic Act 9009, establishing that the cityhood of the 16 cities should be proven by the time point at which they sought cityhood, re-establishing the cityhood of the 16 cities. By the 2010, however, the court voted 7-6, granting the reconsideration of the League and to reinstate its November 2008 decision, once again voiding the cityhood of the 16 cities, establishing the time point of the cityhood bills to be proven at the time point at which the cityhood of the 16 cities was approved, meaning that the new requirements are applied, making the exemption a violation of the Constitution. No city shall be created except by the criteria established in the Local Government Code. The unconstitutionality of the cityhood laws lies in the fact that Congress provided an exemption contrary to the express language of the Constitution. Congress exceeded and abused its lawmaking power, rendering the challenged cityhood laws void for being violative of the Constitution. A year later, the Supreme Court reversed its own decision, establishing the cityhood of the 16 cities as constitutional. So, Yeah, if you're unsure whether the cityhood of the 16 cities was even allowed, don't worry, the Supreme Court was also unsure. By April 2011, the court affirmed the legality of the cityhood. Barely. We should not ever lose sight of the fact that the 16 cities covered by the cityhood laws were not only had conversion bills pending during the 11th Congress, but have also compiled with the requirements of the LGC prescribed before its amendment by the Republic Act No. 9009. Congress undeniably gave these cities all the considerations that justice and fair play demanded. Hence, this court should do no less by stamping its imprimatur on the clear and unmistakable legislative intent and by duly recognizing the certain collective wisdom of Congress. Despite what seemed like a battle between 16 cities and the Supreme Court, it felt more like a character versus self battle. Some members of the League of Cities were open to the new development, but the organization still opposed the 16 cities until 2 years later, when the organization recognized and welcomed the 16 cities into the organization. Despite the decision of the Supreme Court, there are legitimate concerns on both sides. Is it fair to treat the cities at the time they originally sought for cityhood or when they gained cityhood? This question even divided the court, so we will probably not get a definitive answer on this issue other than what we currently have today.